Hello everyone, welcome to Let's Crack UPSC CSE English. In our crash course for Prelims 2021, Inspire. In today's session, we'll learn about public interest litigation, which is known as PIL. Yes. So in today's session, we'll cover public interest litigation. So friends, it's my pleasure to welcome you all on Unacademy, India's largest learning platform where you will get daily live classes, structured courses, unlimited access and live tests and quizzes. It's me, Rushikesh Inamdar, guiding UPSC aspirants from last 8 years. You can follow me on Unacademy and you can also join our Telegram group using this link. Yes friends, so here is the surprise for you. So we are providing 20 books created by best UPSC experts. So you will get these books absolutely free with 1 year subscription. Yes, so you can opt for 1 year, 2 year subscription, then you will get these books absolutely free. Yes. And this offer is valid till 14th April. So hurry up and enroll yourself for us various courses. Now we have mega subscription offer. For example, if you will choose 1 year subscription, you will get guaranteed validity of that subscription till next preliminary examination 2022. And in 2 year plan, you will get validity till 2023 prelims, and this offer is valid till 20th April. Do not forget to use code RBI Live during this mega subscription offer. Yes friends, those aspirants are looking for prepare their examination with our paid courses. We have plus and iconic courses available on our platform. Yes. So, as per your convenience, you can join plus or iconic course where you will get 10% discount after using referral code RBI Live. Yes, friends. So, do not forget to use referral code RBI Live to get 10% discount, and I'll personally guide you throughout your journey of civil services examination preparation. Yes, you will get 10% discount on subscription of optional subjects as well, and we have also subscription combo for GSN optional, like you can go with the 1 year, 2 year and 3 year courses. Yes, so here also you will get 10% discount after using referral code RBI Live. Yes. Now those aspirants are pursuing their graduation or they are planning to prepare for UPSC CSE examination after their 12th examination. They can opt for iconic subscription. Yes, in this iconic subscription, you will get all features of our plus courses. Along with you will get personal guidance, experts guidelines, study material and study planner. Yes. So friends, we are providing free test series for all aspirants who are preparing for prelims this year. So you can go with our complete general studies, current affairs. Yes, and this test series is absolutely free for all subscribers or all aspirants. Just you have to use code RBI Live to unlock these tests. We are going to start new batches. Yes, from today onwards, that is from 7th April. So these batches, like 1 year batch, 2 year batches, NCRT batches and prelims targeted batches. So as per your convenience, you can join these batches. Yes, do not forget to enroll yourself for Unacademy Combat, which is India's biggest free scholarship test we are conducting on every Sunday in the morning 11 a.m. So we have this Unacademy Combat on upcoming Sunday on 11th April at 11 a.m. And now this combat is available in Hindi medium as well. Yes. Now, so friends, link is available in description, so you can enroll yourself with using code RBLI for Unacademy Combat. So friends, now we'll start today's topic, public interest litigation. Yes, PIL. Now we'll learn what is meant by public interest litigation, various provisions related with the PIL and significance of PIL, along with current events related with the public interest litigation. Yes, friends. So, the public interest litigation means litigation filed in a court of law for the protection of public interest. Yes. So, a litigation filed in a court of law for the protection of public interest. Yes. So, any matter where the interest of the public at large is affected can be redressed by filing a public interest litigation in a court of law, such as pollution, terrorism, road safety, constructional hazards, etc. These are the few issues where anyone can file PIL in court of law. So, any public issue, any issue related with public convenience or public related facilities or any provision, or we can say the any matter related with the public interest can be filed through PIL in a court of law. Yes. So now just remember, PIL means litigation filed in a court of law for the protection of public interests. So the concept of public interest litigation, PIL, originated and developed in the USA in 1960s. Yes. Originally this concept of PIL originated and developed in the United States of America in the 1960s. So in the USA, it was designed to provide legal representation to previously unrepresented groups and interests. Yes, it was undertaken in recognition of the fact that the ordinary marketplace for legal services fails to provide such as services to significant segment of the population and to significant interests. Yes. So, such a groups and interests include the poor, environmentalists, consumers, racial and ethnic minorities, and others. Yes, now we are seeing how the concept of PIL was developed in the USA in 1960s. Now, in context of India, The public interest litigation is a product of the judicial activism role of the Supreme Court. Yes. So in India, the public interest litigation is a product of the judicial activism. Yes, we have covered the concept of judicial activism in our previous session. So in India, the public interest litigation is a product of the judicial activism role of the Supreme Court. Yes. So it was introduced in the early 1980s. So Justice V.R. Krishna Iyer, Justice P.N. Bhagwati were the pioneers of the concept of PIL, and PIL is also known variously as social action litigation, SAL, social interest litigation, SIL, and class action litigation. Yes, social action litigation, social interest litigation, and class action litigation. Yes, friends. So, after that, we'll see the meaning of public interest litigation. So, the introduction of PIL in India was facilitated by the relaxation of the traditional rule of locus standi. Yes. So, according to this rule, only that person whose rights are infringed alone can move the court for the remedies, and whereas the PIL is an exception to this traditional rule. So under the PIL, any public spirited citizen or a social organization can move, yes, the court for the enforcement of the rights of any person or group of persons who, because of their poverty or ignorance or socially or economically disadvantaged position, are themselves unable to approach the court for their remedies. Yes. So, thus in a PIL, any member of the public having sufficient interest can approach the court for enforcing the rights of other persons and redressal of a common grievance. Yes. So the Supreme Court had defined the PIL as a legal action initiated in a court of law for the enforcement of public interest or general interest, in which the public or a class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. Yes. So, PIL is absolutely necessary for maintaining the rule of law, furthering the cause of justice, and accelerating the peace of realization of the constitutional objectives. So, in other words, the real purpose of PIL are vindication of the rule of law, facilitating effective access to justice to the socially and economically weaker sections of the society, and meaningful realization of the fundamental rights. Yes. So, the real purpose or purposes of public interest litigation are vindication of the rule of law, facilitating effective access to justice to the socially and economically weaker sections of the society, and meaningful realization of the fundamental rights. Yes. Now we'll see the features of PIL. So, the various features of the PIL, like the public interest litigation is a strategic arm of the legal aid movement Yes, and is intended to bring justice within the reach of the poor masses who constitute the low visibility area of humanity. Yes, PIL is totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character where there is dispute between two litigating parties, one making claim seeking relief against the other, and that other opposing such claim or resisting such relief. Yes, PIL is brought before the court not for the purpose of enforcing the right of one individual against another, as happens in the case of ordinary litigation, but it is intended to promote the vindicate public interest. Yes. Now, PIL demands that violations of constitutional and legal rights of large numbers of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unaddressed. So, public interest litigation is essentially a cooperative effort on the part of the petitioner. So, the state or public authority and the court to secure observance of the constitutional or legal rights, benefits and privileges conferred upon the vulnerable sections. So, this the vulnerable sections of the community and to reach social justice to them. Yes, in public interest litigation, litigation is undertaken for the purpose of redressing public injury, enforcing public duty, protecting social collective, diffuse rights, and interest or vindicating public interest. Yes, so these are the features of public interest litigation, where the role held by the court is more assertive than in traditional actions. Yes, it is creative rather than passive, and it assumes a more positive attitude in determining acts. Yes, though in public interest litigation, court enjoys a degree of flexibility unknown to the trial of traditional private law litigations. Whatever the procedure adopted by the court, it must be procedure known to judicial ten- tenets and characteristics of a judicial proceeding. So, in a PIL, unlike traditional dispute resolution mechanism, there is no determination on adjudication of individual rights. Yes, so these are the features of public interest litigation. Yes, is a strategic arm of legal aid movement, is a totally different kind of litigation from the ordinary traditional litigation, is brought before the court not for the purpose of enforcing the right of one individual against another, as happens in the case of ordinary litigation, but it is intended to promote and vindicate public interest. Yes. So PL demands that violation of constitutional and legal rights of large number of people, including poor, ignorant, or socially economically disadvantaged position, should not go unnoticed and unaddressed. Yes. So PIL is essentially a cooperative effort on the part of the petitioner, the state or public authority, and the court to secure observance of the constitutional and legal rights. In PIL, litigation is undertaken for the purpose of redressing public injury, enforcing public duty, protecting social collective, diffuse rights and interest, or vindicating public interest. Yes. In PIL, the role held by the court is more assertive than traditional actions, and the traditional dispute resolution mechanism. The PIL, unlike traditional dispute resolution mechanism, so there is no determination on adjudication of individual rights. Yes. Now, after that, we'll see scope of public interest litigation. In 1998, the Supreme Court formulated a set of guidelines to be followed or entertaining letters or petition received by it as PIL. So these guidelines were modified in 1993 and 2003. So in 1998, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitions received by it as public interest litigation. So according to them, the letters or petitions falling under the following categories alone will ordinarily be entertained as PIL. Yes, as per the Supreme Court guidelines, the letters and petitions falling under the categories of bonded labor matters, neglected children, non-payment of minimum wages to workers, and exploitation of casual workers, and complaints of violation of labor laws except in individual cases are to be considered as a or entertained as a PIL. Yes. Petitions from jails complaining of harassment for premature release and seeking release after having completed 14 years in jail, death in jail, transfer, release on personal bond, speedy trial as a fundamental right. Yes. Petitions against police for refusing to register a case, harassment by police and death in police custody, petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. So, petitions complaining of harassment or torture of villages by co-villages, by police from persons belonging to scheduled caste and scheduled tribes and economically backward classes, petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife, and other matters of public importance. Yes. So, petitions from right victims and family pension. So, these are the categories falling under, or the latest and petitions falling under these following categories will ordinarily be entertained as public interest litigation. Yes. So, petitions, now we'll see the cases falling under the following categories will not be entertained as public interest litigation, where now we'll discuss the categories will not be entertained as public interest litigation, like landlord-tenant matters, service matter and those pertaining to pension and gratuity, complaints against central state government departments and local bodies except those relating to item numbers 1 to 10 above. Yes, complaint against central state government departments and local bodies except mentioned previous 10 categories. Then admission to medical and other educational institution, petitions for early hearing of cases pending in high courts and subordinate courts. Yes, so these are the categories will not be entertained as public interest litigation. Yes, now we'll see the principles of public interest litigation. Yes, so now we'll see the principles of public interest litigation. So the Supreme Court evolved the following principles in regard to public interest litigation, where the court in exercise of powers under Articles 32 and Article 226 of the Constitution can entertain a petition filed by any interested person in the welfare of the people who are in disadvantaged position and thus not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental rights of such a disadvantaged people and direct the state to fulfill its constitutional promises. Yes, when the issues of public importance, enforcement of the fundamental rights of large number of people, vice versa, the constitutional duties and functions of the state are raised, the court treat and a letter or a telegram as public interest litigation. In such cases, the court relaxes the procedural laws and all the law relating to pleadings. Yes, whenever injustice is meted out to a large number of people, the court will not hesitate to step into, invoke Articles 14, Article 21 of the Constitution of India, as well as the international conventions on human rights, which provide for a reasonable and fair trial. Yes, the common rule of locus standi is relaxed so as to enable the court to look into the grievances complaint on behalf of the poor, deprived, illiterate and disabled who cannot vindicate the legal wrong or legal injury caused to them for violation of any constitutional or legal right. Yes, when the court is prima facie satisfied about violation of any constitutional right of a group of people belonging to disadvantaged category, it may not allow the state or the government from raising the question as to the mentability of the petition. Yes, although procedural laws apply on public interest litigation cases, the question as to whether the principles of res judicata, so the principle that when a matter has been finally adjudicated upon by a court of competent jurisdiction, it may not be reopened or challenged by the original parties or their successors in interest. So its justification is the need for finality in litigation. Yes, or principles analogous thereto would apply depend on the nature of the petition and also facts and circumstances of this case. Yes, the dispute between two warring groups purely in the realm of private law would not be allowed to be agitated as a PIL, and however in an appropriate case, although the petitioner might have moved a court in his private interest and for redressal of the personal grievances, the court is furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. Yes, these are the principles of PIL, where the court in special situations may appoint commission or other bodies for the purpose of investigating into the allegations and finding out facts. It may also direct management of a public institution taken over by such commission. Yes, the court will not ordinarily transgress into a policy. It shall also take utmost care not to transgress its jurisdiction while purporting to protect the rights of the people from being violated. Yes, the court would ordinarily not step out on the known areas of judicial review. The High Court, although may pass an order for doing complete justice to the parties, and it does not have a power akin to Article 142 of the Constitution of India. Yes, ordinarily, the High Court should not entertain a writ petition by way of public interest litigation questioning constitutionality or validity of statute or a statutory rule. Yes, so these are the principles of public interest litigation. Now, after that, we'll see the guidelines for admitting public interest litigation. Yes. Now we'll see the guidelines for admitting public interest litigation. Yes, the public interest litigation has now come to occupy an important field in the administration of law. Yes, it should not be allowed to become publicity interest litigation or politics interest litigation or private interest litigation or paisa interest litigation or middle class interest litigation. Yes, so the Supreme Court in this context observed public interest litigation is not a pill or panacea for all wrongs. It was essentially meant to protect basic human rights of the weak and disadvantaged, and was a procedure which was innovated where a public spirited person files a petition in effect on behalf of such persons who on account of poverty, helplessness, or economic and social disabilities could not approach the court for relief. Yes, there have been in recent times increasingly instances of abuse of PIL. Yes, so therefore there is a need to re-emphasize the parameters within which PIL can be resorted to by a petitioner and entertained by the court? Yes. So the Supreme Court laid down the following guidelines for checking the misuse of the PIL. Yes. So these are the guidelines where the check for the misuse of the public interest litigation, where the court must encourage genuine and bona fide PIL and effective discourage and curb the PIL field for extraneous considerations. Instead of every individual judge devising his own procedure for dealing with PIL, it would be appropriate for each High Court to properly formulate rules for encouraging the genuine PIL filed and discouraging PIL filed with oblique motives. The court should prima facie verify the credentials of the petitioner before entertaining the public interest litigation. The court shall be prima facie satisfied regarding the correctness of the contents of petition before entertaining the PIL. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. Yes, the court ensure that the petition which involves large public interest, gravity and urgency must be given priority over other petitions. Yes, the court, before entertaining the public interest litigation, must ensure that the PIL is aimed at redressal of genuine public harm and public injury. The court should also ensure that there is no personal gain, private motive or oblique motive behind filing PIL. So the court should also ensure that the petition filed by busybodies for extraneous and ulterior motives must be discouraged by imposing exemplary costs or adopting similar novel methods to curb frivolous petitions and the petitions filed or extraneous considerations. Yes. Now, after the principles of PIL, we have covered guidelines for admitting PIL. Now, we'll see road ahead with public interest litigation. So, the court should not allow its process to be abused by politicians and others to delay legitimate administrative action or to gain political objectives. The PIL activist should be responsible and accountable. The court must be careful to see that the petitioner must be acting bona fide and not for personal gain. In shaping the relief, the court must take into account its impact on those public interests. Yes, since it is an extraordinary remedy available at a cheaper cost to all citizens of the country, it should not be used by all litigants as substitute for ordinary oneness or as a means to file frivolous complaints. Yes. Now after that, we'll see recent news related public interest litigation. So various news keeps on revolving public interest litigation in India, as it is one of the most accessible public instruments that can be used to seek judicial action. Yes, so the PIL was moved to quash the Prime Minister Case Fund. Public interest litigation has been filed in the Supreme Court of India seeking directions to the Government of India to make arrangements in order to rescue and bring Indian migrants stranded in Gulf countries. Yes, during COVID pandemic. Then a petition has been filed before the Supreme Court of India seeking direction to states, their municipal authorities and local self-government authorities to ensure the protection of rights of the sanitation workers are also essential service. Provide this amidst the nationwide lockdown in the wake of the COVID-19 outbreak. Yes. Now, after that, we'll conclude with this conclusion. So, public interest litigation has produced astonishing results which were unthinkable 3 decades ago. Degraded bonded laborers, tortured under trials and women prisoners, humiliated inmates of productive women's home, blind prisoners, exploited children, beggars, and many others have been given relief through judicial intervention. The greatest contribution of public interest litigation has been to enhance the accountability of the governments towards the human rights of the poor. Yes, the public interest litigation develops a new jurisprudence of the accountability of the state for constitutional and legal violations, adversely affecting the interest of the weaker elements in the community. Yes, so however, the judiciary should be cautious enough in the application of public interest litigations to avoid judicial overreach that are violative of the principle of separation of power, and beside the frivolous public interest litigations with vested interests must be discouraged to keep its workload manageable. Yes. So these are the conclusions related with the public interest litigation. Now, in today's session, we have covered the meaning of public interest litigation. So, PIL means litigation fight in a code of law for the protection of public interest. So, this interest related with pollution, terrorism, road safety, constitutional hazard, etc. Yes. The concept of PIL originated and developed in the United States of America in the 1960s. Yes. In India, public interest litigation is a product of the judicial activism role of the Supreme Court, and it was introduced in the early 1980s. Yes, so PIL is also known variably as social action litigation, social interest litigation, and class action litigation. Yes, then we have covered meaning of public interest litigation. So the real purposes of public interest litigation are vindication of the rule of law, facilitating effective access to justice to the socially and economically weaker sections of the society, and meaningful realization of the fundamental rights. Then we have covered features of public interest litigation. Yes, So PIL is a strategic arm of the legal aid movement. Yes, public interest litigation is intended to promote and vindicate public interest. Yes. Is the role held by the court in the more assertive than in traditional actions. So, in the public interest litigation, unlike traditional dispute resolution mechanism, there is no determination on adjudication of individual rights. Then we have covered scope of public interest litigation. Yes, so categories falling under the entertained as public interest litigation like bonded labor matters, neglected children, non-payment of minimum wages to workers and exploitation of casual workers, petitions from jails complaining harassment for premature release and seeking release after having completed 14 years in jail, death in jail, transfer, release on personal bond, speedy trial as a fundamental right, then petition against police for refusing to register a case, harassment by police and death in police custody, petition against atrocities on women, yes, in particular harassment of bride, bride burning, rape, murder, kidnapping, etc. Petition complaining of harassment or torture of villages, petition pertaining to environmental pollution, disturbance of ecological balance, drugs, food alteration, maintenance of heritage and culture, antiques forest, wildlife and other matters of public importance. Then petitions from right victims and family pension. Then we have covered the various categories also, which is will not be entertained as public interest litigation. Then we have covered principles of public interest litigation and then guidelines for admitting public interest litigation. Yes. So Supreme Court laid down guidelines for checking the misuse of the public interest litigation. Yes, then we have covered road ahead with public interest litigation and recent news related to public interest litigation. Yes. So friends, that's it for today's session. See you in the next lecture with new topic of Indian polity in our crash course Inspire. Till the time, do not forget to participate or join our Telegram group using this link. And do not forget to use code RBI Life to get 10% discount in our paid course, that is Iconic and Plus subscription. Friends, please like, share and subscribe videos of Unacademy and also hit the bell icon for notifications on YouTube. Yes. So see you in the next lecture. Till the time, keep studying, keep revising. All the best. Take care.